This is Chapter 14, the Federal Judicial System, Applying the Law. The Constitution of the United States established the judiciary as a separate and independent branch. It also established the U.S. Supreme Court, and it gave Congress the power to establish lower federal courts. All federal judges are nominated and appointed by the President and confirmed by the Senate. We've all seen plenty of Supreme Court nominations and confirmations in the past. The most recent one was Justice Kavanaugh a year ago. There are no age, residency, or citizenship requirements in the Constitution, and judges hold their offices during good behavior. The Supreme Court of the United States, original jurisdiction means the authority to be the first court to hear a case. The original jurisdiction of the Supreme Court are disputes involving foreign diplomats or suits between the states. So those cases have to go to the Supreme Court first. Appellate jurisdiction is the authority to review cases that have already been heard. The Supreme Court's appellate jurisdiction are cases arising under the Constitution, federal law and regulations, and treaties. It appeals to legal controversies that cross state or national boundaries. So the Supreme Court selects a case. When the losing party in a lower court case appeals, if at least 4 justices agree to hear the case, the court issues a writ of certiorari, which is a request for a record of the case, and that's also called, quote, granting cert. The court seldom accepts routine cases. They accept fewer than 100 cases a year. There must be, quote, compelling reasons for accepting a case. About 3/4 of the Supreme Court decisions reverse the lower court's judgment. The Supreme Court hearing. During the Supreme Court hearing, the attorneys for each side present an oral argument, typically limited to 30 minutes. Each also provides a written brief. Only the 9 justices attend the judicial conference where the case is discussed and the justices vote. The proceedings are secret, allowing the justices to speak freely. Issuing decisions and opinions. A decision indicates which party won the case. An opinion explains the legal basis for that decision. And there are 4 different types of opinions that the Supreme Court justices have. There's the majority opinion, which the majority agrees upon on the legal basis. That's the winning side of the case, okay? There's a plurality opinion, which is when a majority agree on the decision, but they disagree on the legal basis. There's a concurring opinion, which is a separate view by a justice who agrees with the majority, but disagrees with at least some of the reasoning. And then there's a dissenting opinion, which is when one or more justices on the losing side explain the reason they disagree with the majority position. So these are all ways that the Supreme Court justices can make their individual opinions known, whether or not they agreed with the majority, which is the winning side, or disagreed. They can show levels of disagreement or agreement as well when it comes to the plurality opinion and concurring opinion. So there are many different ways that individual justices can make their opinions known. There are 94 U.S. district courts. They're the lowest of the federal courts, and they're the chief trial courts of the federal system. There are 13 U.S. courts of appeals. These courts hear appeals from the district courts. 11 of the courts have jurisdiction over geographical circuits. 1 has jurisdiction over the District of Columbia. 1 has jurisdiction over patents and international trade. The courts of appeals offer the only real hope of reversal for most appellants. Appellants would be people who appeal their case to the higher court. So this shows you geographic boundaries of the U.S. courts of appeals. For example, when you say the First Circuit Court of Appeals, that would include Maine, Massachusetts, Rhode Island, and New Hampshire. The state courts. Each state has its own court system and decides the structure of its courts and selection of judges. The election of judges is the most common form. In some states, the governor appoints judges, but other states use the merit plan or the Missouri plan. That's when the governor or legislature appoints judges from a list of acceptable candidates. The retention election decides whether a judge stays in office. More than 95% of the nation's legal cases are decided by state or local courts. The president selects nominees and the Senate confirms federal court appointees. The appointment of federal judges is a partisan issue. The federal judges and justices are not free of political views, and the courtroom gives them an opportunity to promote their beliefs. For Supreme Court nominees, nominations allow a president to influence judicial policy for years, sometimes decades, because it's a lifetime appointment. There is a way to remove a justice, but it's basically whether if they have, quote, bad behavior or conduct unbecoming, or it's another vague requirement to remove a justice, but there is a way. Before they die or before they retire. The presidents nominate those with a similar political philosophy. For example, George H.W. Bush replaced a very liberal justice, Justice Marshall, with a very conservative one, Clarence Thomas. So the president doesn't replace Supreme Court justices with another justice who agrees with the former justice's legal opinions. The president will replace the retiring or deceased judge with a judge who backs the president's political opinions. Most nominee rejections occurred before 1900. When there's an open seat on the court, a tie may result, in which case the lower court decision is upheld. For lower court nominees, they are tasked with identifying nominees, and that is delegated to the Deputy Attorney General. The presidents typically nominate members of their own political party. Nominees must be confirmed by the Senate. And senatorial courtesy means that's a tradition holding that a senator from the state with a vacancy should be consulted and can request confirmation, be denied if he or she wants to. The personal backgrounds of judicial appointees. White males are overrepresented on the federal courts. Women and minority group members have made substantial gains in recent decades. Most have been appointed by Democratic presidents. About 2/3 of Obama's appointees are in this group, meaning 2/3 of Obama's appointees were women and or minorities. The Supreme Court has also become more demographically representative. The Supreme Court's diversity of experience, however, has diminished. Most appointees today come from the appellate courts. Political parties, presidents, and women, and minority judicial appointees. This tells you by party how Republican and Democratic presidents go about nominating justices when it comes to personal characteristics such as whether they're women or belong to a minority group. You guys know this from your Supreme Court assignment, but for example, Clarence Thomas, we just talked about him, was nominated in 1991 by George H.W. Bush, and before that, he was a judge on the D.C. Circuit Court of Appeals. The nature of judicial decision-making. Although federal judges make their decisions within the context of a legal system, they are political officials. They constitute one of three co-equal branches of the national government. Their decisions can have both legal and political impact. The legal influences on judicial decisions. There are constraints on the federal courts. The court may only rule upon cases presented to it. The facts of the case are the relevant circumstances of a legal dispute or offense. There are three primary sources of the law: the U.S. Constitution, legislative statutes, meaning laws, and legislative precedents. And that means decisions that are closely related to the legal question being debated at the time, and how that decision was made can affect the decision currently being made. And that's also called stare decisis. The law is not always a precise guide. There is some judicial leeway, and some people criticize the courts for, quote, making law. They're not supposed to. They're not supposed to be lawmakers, but they are supposed to respond to questions on laws. Political influences on judicial decisions. The judges' political beliefs do play a role. They often vote in line with their political attitudes. Not all issues are clear-cut. It is true, though, that some justices have surprised the presidents who appointed them. For example, Justice Anthony Kennedy turned out to be a much more liberal judge than he was expected to be, and he became mostly the tie-breaking vote in a case. Also, let me think. The political influences on judicial decisions. Because right now is the start to the 2019-2020 Supreme Court season, there's some question of whether or not the court is going to run to the right and make a bunch of conservative decisions right away, and whether or not they're going to do that on a political basis, so you can watch for that. There are expectations that the public groups and elected officials also have importance. The court cannot move too far from public opinion. Interest groups file amicus curiae briefs to make their positions known. So they'll give briefs, such as a collection of information, to legislators or to the courts to try to help their case along in some way. Congressional legislation may be rewritten, and judicial appointments offer the biggest opportunity to influence the courts. Judicial review is the power to declare a law to be unconstitutional. That idea, judicial review, came from the case Marbury versus Madison of 1803. And the court's judgment is almost always the final word. So judicial review is when the Supreme Court declares a law to be unconstitutional. The judiciary's power has been a source of controversy. An unelected judiciary and the principle of majority rule. So the court only has power because the citizens give it power. If we decided that the courts don't have any power, meaning they don't represent us and we don't like what they do anymore at all, and if we start to disrespect them, if we don't respect them as a nation, then they really have no power because nobody would implement their rulings. So that's what they mean by saying they're an unelected judiciary, just as many people say about the bureaucracy, that they're unelected lawmakers, basically. And is that right? Okay. So they're unelected. Is that right in a democracy? There are varying opinions on that. And is it fair that majority rule wins the day on a judicial opinion, or should it be based on something else? The judiciary at times has acted almost legislatively by addressing broad social issues and making policy. Judicial restraint is the idea that judges should abide strictly by precedent and legislation, meaning you should apply the law and never create it. Judicial activism is the idea that courts should not blindly uphold the decisions of elected officials when core principles are at issue. That is practiced by both liberal and conservative courts, such as in Marbury versus Madison and Citizens United versus the FEC. What is the judiciary's proper role? As usual, philosophical debates are rampant on this question. The Constitution does not specify the method by which judges should arrive at their decisions. The judiciary acts within a governing system based on often conflicting concepts, such as majority rule, but also minority protections. The judiciary was established as a co-equal branch to protect individual rights and limit political authority. Okay, thank you very much.